Welcome again. My name is Billy Laufer. I am the senior partner in our wonderful diversified law firm. And I first would like to introduce to you one of our speakers today, Judge John Harper, retired judge from the Superior Court of New Jersey. Judge Harper was on the bench for many years. He was in the family division and he was in the law division. And boy, was he a home run. And to our benefit, when he left the bench, he came to my law firm. He's been with our firm for over 15 years, and he has become the master of arbitration. He's appointed by judges to arbitrate complex matters. He's retained by prominent New Jersey lawyers. He handles the most complex arbitration cases in our state. He is a well sought after retired judge. That's Judge Harper. Secondly, you will hear from Peter Bracuti. Peter's been with us for many years. He is a trial lawyer at best. He handles pretty much law division cases and family cases, and anytime we have a complex trial case that needs to go to trial, we look to Peter Bracuti. No one's better than Peter from trying a case from start to finish, and he is usually very successful in his outcomes.
I am John J. Harper. I'm a retired judge of the Superior Court of New Jersey and of counsel with the Laufer, Dalena, Jensen, and Doran law firm. I want to talk a little bit today first about my background, how I got to the position I am in today. I was appointed to the Superior Court and served in that capacity in all three parts of the court. I served in the criminal part, the civil part, and the family part. At one time, I served as the presiding judge of the family part. I also served as the first judge in Morris County to head the drug court. This was a court in which those that were indicted or charged with criminal offenses involving drugs and distribution of drugs were able to serve a sentence and get rehabilitation. So I've had a varied career, and my legal background is as follows. I graduated from Rutgers University Law School with a Juris Doctor degree. Following that, I was practicing as an attorney and also attending night school at NYU University. I have a master's in law with a concentration in labor and employment matters. As I said earlier, I was appointed to the Superior Court, and in that capacity served in all three parts of the court, and I served in the counties of Essex, Morris, and Sussex for the totality of my career as a judge. I retired from the bench in 2008 and opened a law practice here concentrating in mediation and arbitration. It's called alternate dispute resolution. And in that capacity, I have been serving here for some 17 years and handled as a mediator and an arbitrator many, many cases of various types, about which I'll discuss later. My topic today has to do with the benefits of having an experienced and competent person serve as an arbitrator in a binding arbitration matter to assist the parties to settle their disputes. I am proud to say that I have been serving on 5 panels of the American Arbitration Association. I am on the commercial panel, I'm on the construction arbitration panel, the labor panel, the employment panel, and the mediation panel of AAA. I've also served in a capacity as a court-appointed mediator many times for the Superior Court in both the family part and in the civil part of the court. My interest in dispute resolution comes from the fact that when I was in private practice, and I was in private practice and headed my own law firm, I was able to do a lot of labor law and dispute resolution, doing mediation and arbitration for clients as an advocate. I represented initially unions, started on the union side, and then migrated over to the management side before I ascended to the bench in January of 1987. So all told, I'm very familiar with arbitration, and that's my topic today. Binding arbitration and its benefits when you employ an experienced and competent dispute resolver to help the parties settle their matters. Let me explain a little bit about how arbitration works. Arbitration is a process in which the parties select an impartial, a neutral party to hear and decide issues they submit to that party. The party works, the neutral works as a judge would by identifying the issues, by then gathering the information, evidence, both documentary and testimonial, assessing the credibility of the witnesses, formulating an opinion, writing an opinion, and issuing that opinion as a reasonable or reasoned award, along with a reasoned award, I should say. The award functions as the judgment. It is the end result of the process of arbitration. In arbitration, the parties start first by deciding which type of arbitration they want. Do they want binding arbitration, to which they will be required to follow the result, or do they want advisory arbitration? In binding arbitration, the parties formulate an agreement to arbitrate. They decide on some type of organization, whether it be AAA or JAMS or some other organization, which serves as a clearinghouse for experienced arbitrators. As a retired judge, having tried and or settled a number of cases in my career on the bench, I know the benefit of having an experienced person serve as an arbitrator. And after the agreement to arbitrate has been reduced to writing and signed by the parties, and they've selected the method they wish, binding or advisory, they then proceed, and a demand for arbitration is made, is filed. It's similar to a complaint being filed in court, followed by what is called a response. The response is typical in the fact that it resembles an answer. Perhaps even there may be a counterclaim that is put forward. And then there would be a reply to the counterclaim by the initial claimant. After that process, you would then proceed in accordance with the rules that you have adopted in your agreement to arbitrate. The rules will govern how discovery takes place, whether it's extensive or limited, whether the parties can use, at the request and with the permission of the arbitrator, dispositive motions to resolve their case. And then the rules will govern how the hearing goes forward. As I say, it's similar to how a judge would hear the case sitting as a judge in this matter. Determining credibility, evaluating the evidence, formulating the decision, writing the opinion, and issuing the award. And then the outcome can be enforced in a court of law. The outcome is in the form of the award. The parties, after the arbitrator issues his decision, can then move to vacate the award if they feel there's some error that's been committed. They can affirm or confirm the award by an application to the court, or they can simply move to vacate. The move to vacate would result in the court making the decision because either there was fraud perpetrated on the arbitrator, or there was undue influence, or some other egregious conduct by the arbitrator or the parties. The court could vacate the decision. However, if the court confirms the award, it's enforceable, and the parties have the benefit of a judgment. The beauty of this whole process of arbitration is it's less costly than a court proceeding because there's limited discovery, less time taken up. An arbitration typically, from the time of filing of the demand to the issuance of the opinion of the award, is less than 1 year. Court cases today are materially and appreciably longer in duration. They can take 1, 2, 3, and many years, depending on the litigiousness of the parties and the workload that the judge has to face. Judges today have heavy dockets. They have a number of cases to which they're assigned. They have responsibilities over a wide area, depending on their expertise and the part of the court in which they sit. So you can see that over time, it is not unusual for a court case to exceed substantially the length of time taken up in an arbitration. So I like to say use arbitration because it's less costly, it's more efficient, it's more expeditious, it can be much more effective, and it produces the same result or outcome as if a judge tried the case sitting without a jury. That is to say, you make the award by a confirmation enforceable, and the parties are then directed to follow it. So all told, I cannot tell you how pleased I am to be in the role of an arbitrator when the parties select me through their processes to serve as the impartial. And I urge you to consider the use of arbitration. It does not matter what type of case you have. The substantive law can abide and wait because the process is, the beauty of arbitration is that it's cost-effective, efficient, and will inure to the benefit of the parties to get a decision a lot faster. So I wish you well in making a decision as to how to proceed. Thank you very much.
I'm Peter Bracuti. I'm a partner at Laufer, Dalena, Jensen, and Doran. I've been with the firm since 2018. This year marks my 27th year practicing the majority of matrimonial law. My role at the firm, in addition to my own clientele, is that I am primarily responsible for trying cases. That responsibility entails trying my own cases as well as taking other people's cases or other attorneys' cases to trial. Now, I don't take a case with the intent on trying it, but I do believe that trying a matrimonial case is a very useful skill, and it also helps in settling cases. So when I take on a case, I always prepare it for trial from the get-go, and I do that for a variety of reasons. The first reason is that when you take on a case and you prepare it for trial, you will never know the case better than when you do when you prepare it for trial. Also, when you prepare a case from trial from the immediate inception of the case, you also don't have to run into the situation where if 2 years later and the case does go to trial, you're not prepared for same. Now, I don't take cases on with the intent on trying every single case. In fact, statistics will show that only between 2 and 5% of matrimonial cases actually go to trial. And I think if I looked at my own roster of cases, that percentage will actually hold true for my cases as well. However, there are a percentage of cases that do go to trial. And if you are one of those cases, it is important that you have an attorney that is familiar with the trial process and is not intimidated by same. I would say during the past 5 years, I've tried upwards of 2 cases on average per year. And in every single case that I have, in my initial client meeting, I explain to the client what it entails to try a case and why you should be prepared for same. And one of the first conversations I have with a client is the cost-benefit of trial. When it comes to monetary disputes, an attorney always must advise their client, is the cost of trial outweighed by the cost of achieving your ultimate goal? The classic example would be spending $100 over a dispute over an item of personal property that's worth $10. I understand that matrimonial cases are highly emotional, but it's the attorney's job to try to advise a client not to take unreasonable positions that are not cost effective and are not cost beneficial to the client. One of the other things that needs to be discussed with the client is the expense in terms of both monetary, time, and emotion. Trials can be very expensive propositions. Clients are oftentimes led to false assumptions as to how a matrimonial trial actually takes place. Clients these days are used to watching things on the internet and television where they'll imagine that a trial starts on a Monday and continues until it's finished. That is certainly not the case in matrimonial courts, especially given the extreme congestion of our matrimonial courts. It is rare in a matrimonial matter that a case would start and continue on continuous trial days every day until completion. In fact, it is rare that you get more than 2 or 3 trial dates consecutively. This past year, I've had 2 trials. Each one has taken upwards of 5 months. I've had 2 cases in my career that have taken over 1 year to try, and the problem with that is that leads to expense. It is one thing to go to court and be there for 5 straight days. It's another thing to prepare your client for trial, have 2 days of trial, and then come back 3 months later, which is not out of the ordinary. Also, even when you do go to trial, it is extremely rare that you will go to trial on a Monday, let's say, at 8:30 in the morning, and then continue the trial until 4:30 in the afternoon. In fact, when you have a trial date, once again, due to the congestion of the courts, it is rare that you will get onto the start your case and continue it throughout the entire day. In fact, I believe it's probably a good assumption that if you try your case, you're lucky to get 2 or 3 hours of actually court time in on a particular trial day. As such, trials can be extremely expensive propositions when it comes to the cost involved with same. Now, those conversations are relatively easy when we talk about monetary disputes. When it comes to child-related disputes, those conversations are much more difficult. I cannot put a price tag for a client on safeguarding a child's best interests. Those are more difficult cases in terms of cost-benefit analysis. I cannot advise a client as to the cost-benefit of how much time their child is worth to them monetarily. Also, one must factor in is the emotional cost of trying a case, a matrimonial case. You'll be in a courtroom in front of strangers discussing sometimes the most intimate and embarrassing details of your life. This will occur over the span of sometimes weeks, months, or even years. Again, a client must be prepared to the prospect of testifying in a highly emotional charged environment in front of strangers and being confronted with their estranged spouse. Now, once all those conversations take place, I believe it is important that a client understand the prospects of trial and to agree that their case may in fact go to trial. Once you start a case being prepared for trial, you will know the case better than you will ever know it otherwise. I often find that in order to achieve a fair settlement, there is no substitute for information. And the best way to obtain information is approaching a case as if it is going to be tried. I am only as good as the information that I am armed with in terms of representing a client. So, in order to effectively prepare a case for trial, we must do our own investigations. We must be able to know all the assets and the income in the marriage in order to properly advise a client. Finally, one of the most important reasons why you take a case to trial or prepare a case as if it's going to trial is to achieve a good settlement. Most attorneys and most clients are fearful of the trial process with some rational reasons behind same, as I just explained. However, you oftentimes, when settlement negotiations break down, invariably a court or an adversary will say, well, then I think we'll have to try the case. That is not something you should be afraid of. It should be something you should be prepared for. And if you're prepared for trial, I have found that the most beneficial way to achieve a fair settlement is for the client and the attorney to be able to say to the court or the adversary, we are prepared for trial. Oftentimes I find that when an adversary is faced with that response, their settlement positions soften and we can have a more productive dialogue because they understand that me and my client are not afraid of the trial process.
Well, Billy, we just finished up an awesome segment with retired Judge John Harper and also Peter Bracuti, who talked all about trials. So interesting to listen to and hear about that.
Well, you know, Judge Harper, judges can retire from the bench when they're 65 years old.
Okay.
And then they get a pension. And after that, they can continue on till they're 70 and their pension increases. But when they leave at 65, they can then go out and join a law firm.
Oh, so why would you say he joined your firm?
Because after on the bench for so many years, he decided that he wanted to get back into basically more the practice of law. And he basically was so good on the bench, he could have gone anywhere he wanted to go. But he came here. Yes. Because only if you like perfect.
And Laufer, Dalena, Jensen, Doran LLC.
Yeah, so he came back to this law firm. He came to this law firm, and we were so fortunate to get him. It was a major, major coup for this firm to basically get Judge Harper to become an of counsel in our law firm. Now, as a retired judge, you cannot try cases in the courtroom because you're getting a pension from the state of New Jersey. So you can't try cases. Only thing you can do then, you can be an arbitrator or a mediator. You can't go into the courtroom and argue cases. So that's what his forte came into place. And as soon as he went out there, and these other judges knew him, and they had to refer something from him to mediate a case or arbitrate a case, they knew who the player was, and they all went to Harper. Yeah. And he developed such a beautiful practice over the, he's been doing it for 15 years. Unbelievable. Yeah, 15 years. And he brings in the clients, the judges like him, and he, again, he knows how to pull the trigger. He's a very decisive guy. You listen to him. He calls the shot. As an arbitrator, you're basically a hired judge. Yes. You arbitrate. You pay the arbitrator, and he is the judge. And what he decides is the law. It's the case. It's binding on the parties, and he's got it, and he's always had it, and he loves what he does, and he's going to stay with me probably for as long as I'm here. All right?
Yeah, it was great to hear what he had to say. He's so knowledgeable about the arbitration specifically, but he's also such a sweet and kind guy.
You know, he obviously got to you too, you know?
Yeah, oh, he did. I'm a little biased over here.
Yeah, no, I bet. I think of all the people that we've interviewed so far, I think you have said the most, really the nicest, kindest, and remarkable things about Judge Harper, and I get it because that's who he is.
Yeah. I would be really lucky to have him as my arbitrator.
See, there you go, perfect example.
Absolutely.
I know. So that's why he's chosen.
And we also spoke to Peter Bracuti.
Peter's So Peter, it's always good to have in a law firm a person that that enjoys going to court and trying cases. A lot of lawyers are great lawyers, but they don't love going into a courtroom and trying a case. Yes. You got to have that extra in you to be a litigator. So some lawyers in this firm bring in great clients. They're just not looking to go to trial. So what do? We go to Peter Bracuti because Peter is a major, major adversary. He can try any case you give him. He's good. He wins most of his cases. Yeah. And when you give him a case to try, you know it's going to be start to finish, top notch. You know, he's really good at it. So it's nice to have him here. I don't need him because I like to litigate myself. I'm a trial lawyer. But there's other lawyers in this firm that need Peter Bracuti. Yeah. And he's excellent at what he does. So
Yeah.
And he wins most of his cases, which is kind of interesting. I can't say that about everybody.
Well, only if you like perfect.
Only if you
he
like
wouldn't. He
perfect.
wouldn't be here otherwise.
No, he's good.
Just kidding,
He's
just
been
kidding.
terrific with this law firm. So.
Yes, and I'm so happy to have met all of these people so far. Everyone is great, is wonderful.
Pretty good firm, huh?
Yeah, you got a really great firm actually.
I know. And what you're doing for us is great. You know, it's easy to practice law. It's easy to hold yourself out there. And sometimes we need people like you. Well, no, to bring us to the next, to let the public really know that we're here and what
Yes.
we're all about, as opposed to, you know, just having a website, you know, etc. This is really a wonderful thing, and I know you're going to promote us.
Yes, of course, outreach, and we love to share everything you have here. And you can watch on our website, jjaproductions.com, and we are going to have it on yours as well.
Can't wait. Love continuing to work with you, and let's see where this takes us.
All right.
All right.
Stay tuned, everybody, and only if you like perfect.
Thanks, Jordan. You're great. I really appreciate it. It's good. Huh?
I appreciate
You
you
should
too.
be a lawyer.
Oh, I should be a lawyer. I don't know about that. Thanks so much, Billy.
Okay.